All right, calling People versus Kelly Marie Bryant, case number 250216FY.
Good afternoon, Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Carandago up here on behalf of Kelly Bryant. She's present via Zoom, Your Honor. We have no objections to Zoom.
Thank you. Ms. Bryant, would you state your name for the record, please?
Kelly Marie Bryant.
Thank you. Ms. Ferenczi, this was People's motion to restrict communication privileges from the jail.
That's correct, Your Honor. As I noted in my motion that was filed last week, the people became aware that defendant had been calling the minor victim's caregiver on a daily basis, sometimes multiple times a day, which is in violation of the custody order that was dated March 7th, 2025. I do not believe that defense is contesting the fact that these calls were made. The people do have witnesses on standby if the court does wish to hear testimony, but that is the reason that this motion was filed.
All right, thank you. Ms. Carandago?
Yes, Your Honor, just ever so briefly. So it's my client on the phone call, so that's not really the issue here. The issue that I brought up in my answer, so the people did provide, I want to say about 20 phone calls. There's one single phone call, which was actually prior to the court holding the bond hearing on the 7th. So it was on the 7th in the morning where the caregiver volunteered some information to Ms. Bryant. Ms. Bryant didn't ask, on none of the phone calls, Ms. Bryant is asking about the children. The issue that we're having is that Ms. Bryant, after the court hearing, so the court held a hearing, made its oral ruling, and then Ms. Bryant nor myself were ever provided with a written order. I don't believe that Ms. Bryant, so we weren't provided with a custody order, nor a pretrial release order, nor anything else in writing. Ms. Bryant was under the impression that she was not allowed to talk about the children, inquire about the children, not even ask how they were doing, and she didn't do any of that, Your Honor. Had Ms. Bryant or myself been provided with a written order, I had to go and listen to the hearing again when Ms. Ferenczi called me and indicated that she was filing this motion because I didn't have recollection of that part of the order. I knew that Ms. Bryant couldn't have contact with the children or ask about them or, try to pass messages or anything like that, and she didn't do that. I did listen to the recording back. I spoke to Ms. Bryant. I emailed the court asking for the order because there was no bond order ever provided to her or myself. I was mailed out a copy that I received a few days ago from the JIS printout, so the register of actions basically that had the bond conditions on them, and I myself provided them to Ms. Bryant yesterday. Neither one of us have still received a custody order or a pretrial release order. And so my position is to revoke all of her privileges at the jail, her communications privileges, with what I believe is A, defective notice in writing, and B, she's never engaged in any kind of inquiry or anything in regards to the children. I don't believe it's appropriate. I don't think the people, unless I'm missing something, are disputing the factual statements that I'm making in regards to the content of the phone calls, nor do I think they have any specific knowledge that Ms. Bryant was actually served with any of the orders. So I'm asking, and I'm just going to tell the court, if I had heard the courts, I know exactly what the court said now because I went and listened to it again. If I had known, I would have had a conversation with Ms. Bryant, but I would also have addressed it immediately because part of the problem is when the court, the court reduced the bond has to be posted somehow. Those were the contents, I want to say, of 95% of the conversations, including the calls that were made by other inmates. Those were only in regards to her bond. So the statements made by the people, and quite frankly, every day in the media since this came about, that Ms. Bryant is somehow reaching out to the children, trying to talk to them, it's just simply not true. So at this time, I'm asking both that the court allow for contact with the caregiver unrelated to the children, which I don't think the people can say that my client ever uttered a word about her children, and at least on the recordings I was provided. And they monitor those calls, so they know if she talks about the children. or if the caregiver talks about the children, which is not the case, that you allow that type of contact with the caregiver because it is the media for her bond issues, but also that you allow her privileges to remain intact. I don't think it's appropriate to revoke them at this time. I did provide her with the order. I don't believe there's been any further reaching out or nothing like that pending the court's decision today.
One thing before I go back to Ms. Ferenczi, it is customary for the court to enter the orders and restrictions from the bench. And the court reviewed them on the record, reviewed them at the time of the hearing, so I don't think there was anything unclear about what the court indicated. But Ms. Ferenczi, any response?
Thank you, Your Honor, I appreciate that. Judge Walker, I agree with that statement. You provided the defendant with actual notice on 3/7/2025. You were very clear in your holding, in your ruling. You stated that there should be no contact. Your exact words are no contact with alleged victims, including no personal contact, no reaching out to parties who have control of those children, no contact with them whatsoever. Ms. Bryant had actual notice that day. Your Honor, there is a reason for these no contact orders. As the court is well aware, there are also reasons for bond, which includes the assurance that the defendant appear in court and that the defendant comply with court orders. At best, defendant is skirting the line of compliance here, Your Honor. She didn't understand, she didn't know. That is simply not a defense, especially as she had actual knowledge and actual notice on 3/7/2025 with what the court ruled on the record. Your Honor, my concern is twofold. First, that Ms. Bryant defied the court's order on 3/7/2025 with the no contact, but also is now circumventing Oakland County Jail's rules and having other inmates contact on her behalf, which is in violation of their rules as well. Your Honor, there are multiple reasons for, and I'm not going to belabor the record, the importance of no contact orders. Victim preservation is first and foremost to protect the alleged victims from potential intimidation, harassment, or further harm by the defendant. These victims have gone through trauma and have been going through trauma for years. It only benefits everyone involved to have separation, which is why this court put in place the no contact order with both the victims and also the people that are charged to protect them right now. And I do believe that this is a clear, on its face violation of the custody order that the court put in place on 3/7. And I do believe that the request to revoke these communication privileges is valid, and I ask for the court to do so.
Now, the court has not heard any of these recordings, so I am relying on those who have reviewed them. So, in any of the recordings, has there been any attempt to contact or have conversation with the children?
Your Honor, if I may respond, there has not been any attempt by Ms. Bryant to make direct contact with the victims. There has been one call that I believe Ms. Karen Dongo just referenced, where there was a discussion about appointments.
And Yana, if I may clarify, the caregiver brought it, they weren't even talking, they were talking about something completely unrelated. The caregiver mentioned that, well, I guess I'm not going to say it on the record. I think the court knows what, but mentioned an appointment.
Okay. Let me
Didn't
just be
say
clear.
where it
Let me just
was.
be clear about one thing, because at the time
Yes.
the court imposed these conditions, the purpose was to protect the integrity of the judicial process, make sure there was no tampering with any witnesses of any sort. And the court at that time did not even know exactly who the caregiver was. But the intention to protect that was to make sure that there was no contact with the victims or anyone who's caring for the alleged victims, so that there is no attempt to influence potential testimony in this case. So that was one of the reasons for that.
And
Right
there's been
now,
none of that, Your Honor. Sorry.
right now, the types of communication that the defendant has is what, through tablet?
That
Yes,
is
and
my
the phone,
understanding.
Your Honor.
Tablet, phone?
Tablet and the phone. Correct.
Okay. Any other forms of communication?
Not that I'm aware.
Not that I'm aware either.
Okay. Is the potential there for the jail to restrict contact to specific phone numbers?
I don't believe so, Your Honor, but I'm gonna tell the court if the court is, she understands now, and if the court is not modifying that, I am telling the court that there's not gonna be any other issues. There will not be any other issues. They can monitor her from now until eternity, and she will not violate the court's orders.
I'm not
But I don't
understanding,
think there's an
I'm
ability
not
to do that.
understanding why other inmates have made calls. That is just baffling to me.
It would explain it on the calls, Your Honor. So Ms. Bryant is housed, first she was housed in the clinic for a number of time, for a number of weeks, I believe. Then she's housed in a single-man cell. They allow her to exit the cell, I believe, once a day. And the phone calls that were made by other inmates were in regards to the bond, so whether there had been, I think one of them had asked if the caregiver had spoken to another family member of Ms. Bryant's because it had to do with, where she was going to be when she got out from jail. And all of the other calls were in regards to either reaching out to a bail bondsman, inquiring on whether the caregiver had received a phone number for, a specific bail bondsman. That was the gist of it. Those calls, I think the longest one was 1 minute and 4 seconds. All the other ones were much shorter. There were no discussions about anything else. And the reason it was done, and I don't know, I know you can't do three-way calling. There were no three-way calling. But the reasons that was done is because Ms. Bryant couldn't get out of her cell. And it was after, the court had modified her bond and my client is trying to raise the money to post bond. So there was no discussions either, but that was the reason. And I'm being, as forthcoming I can with the court. It's pretty clear from the phone calls that that's the reason too.
At this point, it appears to me that there was a flagrant violation of the court order. I am confident that you have now reviewed this with her, Ms. Kirandongo, with your client, Ms. Bryant, so there would be no additional such calls. However, the violation is a flagrant one. So I am going to temporarily suspend her jail communication privileges for a period of 1 week because I want to make sure that she understands the court orders are exactly that. They are not suggestions. They are not hopes that you will comply, but I expect strict compliance with the no contact provisions. So I am going to indicate there will be a 1 week suspension of any jail communication. And then, Ms. Ferenczi, if in communication with the jail, there can be follow-up to make sure there are no other violations, because if there is another violation, the court will schedule an emergency hearing within 24 hours of receiving notice of a violation.
Yes, Your Honor, thank you.
Your Honor, is it at all possible, I know the court is a little bit restricted, but is it at all possible to have a bench conference about a separate issue?
I can't do
If it's
that
not,
right
we can
now,
communicate.
simply because we have a 3 co-defendant homicide probable cause conference right after this one.
We'll communicate with the court in writing then,
That's fine.
between Ms. Ferenczi and I. Thank you, Your Honor.
All right, thank you. Bond is otherwise
Thank you, Your Honor.
continued.